ಅವರು ಹೊಡೆದಿದ್ದಾರೆ ಸರ್.
ಅದಕ್ಕೆ ನೀವು ಹೊಡೆದ್ರಾ?
ಇಲ್ಲ ಸರ್,
ಮತ್ತೆ
ಅವರು ಫುಲ್ ಬುಕ್ ಎಲ್ಲ ಬಿಸಾಡಿ.
ಏನ್ ಬುಕ್ ಎಲ್ಲ ಬಿಸಾಡಿದ್ರೆ ಅವ್ರು ಮ್ಯಾನ್ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ಯಾ? ಹೂ ಗೇವ್ ಯು ದಟ್ ರೈಟ್?
ಫುಲ್ ಇಲ್ಲ ಸರ್, ಅವರೇ ಹೊಡೆದಿರೋದು.
ಯಾರು ಹೊಡೆದಿರೋದು? ಸಿಸಿಟಿವಿ ಅಲ್ಲಿ ಏನ್ ಕಾಣ್ತಾ ಇದೆ? ಸಿಸಿಟಿವಿ ಫುಟೇಜ್ ಅಲ್ಲಿ ಏನಿದೆ? ಯು ಆರ್ ಮ್ಯಾನ್ ಹ್ಯಾಂಡ್ಲಿಂಗ್ ಹರ್, and instead of registering a crime against that auto driver, you registered the crime against the advocate who has been beaten by the auto driver. What sort of policing is this?
ನಾವು ಹೊಡೆದಿಲ್ಲ ಸರ್.
ನೀವು ಹೊಡೆದಿರಲ್ಲ. Get in the entire CCTV footage. I'll direct inquiry to be conducted against these people.
17th I'll get.
List the matter on 17th. Both of you be present. In yaar idro station will get all of them.
CCTV footage I have.
Let my learned friend give me a copy.
Give the CCTV footage. Video will tagdidre, give everything. He has produced it. You are beating that lady. You will face the music. All of you will face the music. What do you think? You have to protect law, or do you have to take law into your hands and beat anyone? Auto driver may complaint kodi anta station ge, if she comes, you have beaten her only.
Sir,
Advocates, yes, sometimes are vociferous. That means that you should beat them.
ನಾನು ಬೇರೆ ಸ್ಟೇಷನ್ ಸರ್, ನೈಟ್.
ಯಾವ station night duty ಗೊತ್ತಾಗುತ್ತೆ ತಾಳಿ. Whoever was there will get the CCTV footage. Jagdish?
Yes, my lord.
I had asked you where is the.
Yes, my lord. I thought the lordship have it on 16th or 17th.
No, I want all the information about what happened to her complaint.
Yes, my lord, I'll get it.
The advocate is assaulted by an auto driver and complaint is registered against her.
I've seen the car, vehicle also been damaged.
Yes, vehicle is damaged, stone is thrown on the glass. And police, and who is that lady police?
I was present, my lord, but.
And who is that lady who has assaulted the other lady here?
Both are present.
Who is present?
Both are. One Padmavati and Murali.
Who is that Padmavati? Get her here. Call her here.
It was she who assaulted the deputy.
Wait. Yes, Mr. Ivo, come here. Why is the advocate beaten? Who is that Padmavati? Call that lady. Yes, come here. Why did you beat the lady? ಯಾಕೆ ಹೊಡೆದ್ರಿ?
ನಾವು ಹೊಡೆದಿಲ್ಲ ಸರ್, ಅವರೇ.
ನಿಮ್ CCTV footage ಅಲ್ಲಿ ಇದೆ ಎಲ್ಲ.
17th.
You produce everything.
Let him also give me a copy in advance.
Give it. List the matter on 17th. In the fresh list the matter on 17th at 1 p.m. Let them be present.
17th, any date.
Yeah.
16.
After 17, 16 doesn't come, sir. Please keep quiet, sir. It is between the court and the police. CCTV court bidi. Please keep quiet. Yes. Adjournment keltare. You know seriousness of the problem.
16.
17th. Yes. CCTV footage, give it to the additional SPP and get all the officers of the police station of that day.
ನಂದು ಕ್ಯಾಮೆರಾದಲ್ಲಿ ವಿಡಿಯೋ ಮಾಡ್ಕೊಂಡಿರೋದು, that is not clarity. ಅವರನ್ನು ಪ್ರೊಡ್ಯೂಸ್.
ಯಾವ್ದು ಕ್ಲಾರಿಟಿ ಇದೆ ಅದು ಕೊಡಿ ಸರ್. ಇಲ್ದರ ಐ ವಿಲ್ ಗಿವ್ ಯು ಕ್ಲಾರಿಟಿ ಇನ್ ದಿ ಆರ್ಡರ್.
My lords, I have cartelized with my friend that whatever time I can save, I can give it to her. So, my lords, I appear for Samsung, my lords.
The strongest submission will come at the end.
Absolutely, my lords. We must save the best for last.
Yes.
My lords, I appear for Samsung, my lords. I am also a manufacturer. I am not in the three categories which are caught in the 26(1) order. I am neither Amazon, neither Flipkart. I am neither their affiliate, nor am I a preferred seller. And these three categories come from the 26(1) orders, also come from, my lords, and I show this in my earlier arguments, my lord, that the notices that were sent to me also refer only to these three categories, do not at any point refer to a manufacturer. I am in that category, my lord. My lords, but the issue with this case, and my lords, the procedure adopted by the CCI is not only, in fact, only to this case, it is generally the procedure adopted by the CCI and the DG in all cases. And therefore, after 17 years of CCI, of competition law enforcement, it is important, my lords, that there is clarity on this issue. Because without it, my lords, we will only see more litigation, and parties, my lords, will suffer because they are prejudiced, because their rights under procedural rights, substantive procedural rights, as well as natural justice rights have been denied to them. Let me just point out two instances which apply to me here, my lords. Number one, my lords, there is a dawn raid, a search and seizure operation that takes place in Apario's office. I believe Mr. Povaya was present. Those search and seizure takes place, my lords, my employees just happen to be there. My materials are seized, my phones are cloned, my materials are taken. Till date, I do not have a copy of that order. of the warrant order by the Chief Metropolitan Magistrate has not been served on me. No Panchnama has been given to me, despite my materials being taken away. That, my lords, is the fact, is the way in which this investigation has been conducted. My lords, second point is the CCI itself, my lords. Who makes me a party, my lords? It is, in fact, not the CCI who makes me a party. It is, I showed it during my arguments, my lords, at para 8.26 of the DG report. The DG report says, accordingly, the names of the enterprises violating Competition Act and the individuals liable under the provision of section 48(1) of the Act is shown in table 154. The CCI, my lords, does not apply any mind.
Correct.
In fact, to use my,
Whatever DG has done, CCI says.
without any application, my lords. In fact, my lords' words have been that it should not only be application of mind in law, in ink, it should be in law. It is neither here. No ink, no law. My lords, what happens instead is the CCI does administrative splitting, which is not allowed. My lords, there is no provision. Yes, CCI has broad powers to regulate its own procedure, but the law, my lords, starting is the CCI's own procedure says, if I see similar causes of action, I will club them. So prior to section 26(1) says so. Now, in fact, now through the amended 26(2)(a), it says that in case this issue has already been decided by the CCI will not go into this issue. Why, my lords? Because for the same cause of, my lords, competition law works in the concept of, especially in section 3(4), which is vertical agreements, my lords, looks at the cumulative effect of the conduct. It looks at whether or not there is foreclosure effect. That foreclosure effect, while splitting this matter for administrative reasons, what it does, it fastens me with at least the ability of the CCI to say, I will fine you in both, penalize you in both cases. When the conduct in question, if at all, even if I accept that there is conduct in question, my lords, that conduct is exactly the same from a competition law point of view. And my lords, that brings to what is competition law? What is competition law concerned with, my lords? It's concerned with healthy competition. When you do competition law enforcement, my lords, competition authorities the world over are concerned with the biggest fear they have. That fear is of false positives. How does a case in which rule of reason applies, in which the DG has to come to a finding of appreciable adverse effect on competition to finding of contravention of the Competition Act, does so without me reading any evidence, without I getting any opportunity to cross-examine anyone, or leading any economic evidence to say there is no effects. In the absence of that, how is the DG even come to that conclusion, my lord? Is a question which must be answered, because what happens, my lords, in fact, I have the privilege of been appearing before the commission since the last 17 years, my lords. Every DG report starts with probably 4 or 5 defenses. Cherry-picked evidence, no evidence, lack of evidence, lack of logical reasoning, no opportunity given, lack of cross-examination. That is the standard playbook of every defense, my lords. But these safeguards exist today. Those safeguards are there when the Delhi High Court says the trial starts when the DG starts its investigation. That's a trial, my lord, in which substantive procedural safeguards must be, national justice must be followed. My lords, when the DG has powers to allow cross-examination, to examine on oath and then allow cross-examination, that points to those powers, that it is in fact exercising, and regulation 43, my lords, which prohibit the taking of evidence or subsequent taking of evidence by the CCI to say, so my lord, it is no answer that the CCI will give me a fair hearing now, because that hearing has already been lost as far as I'm concerned. And in fact, my lords, it creates discrimination. Amazon and Flipkart, who have been parties to this matter since day one, have had the chance to lead that evidence. I have not been. It is a violation of Article 14. My lords, in fact, so powerful, and the weight of the DG report is such, my lords, that there are 3 decisions of the erstwhile Competition Appellate Tribunal. In the case of JP, Jayaprakash Associates, in the case of BCCI, and in the case of Coal India, where they say if the CCI were to disagree with the DG report, it must give the other side a notice of disagreement. So it is not merely a recommendation.
No, that is rudimentary. Because if it is going to disagree with a report that is favorable to a person,
yes,
it has to issue notice. That's all.
Right. Which is therefore it is not simply to say it is a recommendation I will accept or reject. I must follow a procedure, because that report is
no, here everything is ordained by procedure. It is nothing is left to ambiguity. Whether it is followed or not is what is to be seen.
And my lords, and whatever ambiguity was left, the Supreme Court has shown light on it as far as short glasses. My lords, those are my humble submissions. I am very grateful, my lords. Thank you. Yes, it. I said I'll give it to her, my lords. I must keep my promise.
Yes. Yan galate madidra alli?
Illa sir, nanen madliಲ್ಲ ಅವರೇನೆ.
Maintainable. Yan maintainability ಯಾಕೆ?
Maintainability.
No.
They have infringed my right.
Huh?
They have delivered a judgment.
Delivered a judgment.
They have not allowed me to argue my case, sir.
Without that, they delivered judgment.
Yes, sir. They have given the judgment. I'm stating that while arguing, they stopped me.
Stopped you?
Stopped me.
not to argue, and I will decide the case as per law.
ಏನ್ ಗಲಾಟೆ ಮಾಡಿದ್ರ ಅಲ್ಲಿ?
ಇಲ್ಲ ಸರ್,
ಮತ್ತೆ?
ನಾನೇನ್ ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ನಾನು ಆಯ್ತು ಸರ್ ಅಂತ ಒಬ್ಲೈಸ್ ಮಾಡಿದೆ.
ನೀವು ಒಬ್ಲೈಸ್ ಮಾಡಿದ್ರ ಕೋರ್ಟ್ಗೆ?
ಅಲ್ಲ, ನಾನು ಒಪ್ಕೊಂಡೆ.
ಒಪ್ಕೊಂಡು.
ಓಕೆ ಸರ್ ಅಂತ. 7ನೇ ತಾರೀಕು ಅವರು 7/1/26 ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರು. ಅದರಲ್ಲಿ ಮತ್ತೆ ನನಗೆ ಅವಕಾಶ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಮೇಂಟೈನಬಿಲಿಟಿ ಓವರ್ ರೂಲ್ಡ್ 16th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ 16.
ಓಕೆ ಸರ್.
94